Good evening. How is everybody doing tonight?
Huh.
Hopefully,
Hello
every,
there.
hopefully everybody is doing well. I hear we might have some new visitors this evening, so I've put my actual real name there for everybody. It kind of takes the fun out of it for others, I think.
I think so
So
too.
yeah, Heather's my real name. I've never hidden that. Most of us on YouTube do have different names because doxing is a real thing. And I'm talking, horrible kind of doxing things. But yeah, Heather's my real name. So there it is. Nobody has to out it now.
Hmm.
Hopefully everybody feels better with that. So that's out of the way.
Well,
Um,
I'm going to add to that just
Go
a
ahead.
touch, just because of my experience. That this is my first time with YouTube channeling at this kind of thing, and one of the things I learned early on is why you take on a pseudonym, and I realized that when I got my first threat over this specific case. Somebody had threatened me and my job, and so I can see why one would take up a layer of protection. So I don't think it's a bad thing. People all over everywhere take up
Yeah.
different names for protective purposes, specifically when you have family and friends and a life to protect. So there's that.
Absolutely. And actually, I can give a background on where Carrie Moody came from.
I do have
So,
questions
about
about that.
3 years ago, yeah, about 3 years ago, I was doing creating like Amazon coloring books and stuff, like really cool, fun just really fun stuff and I was creating those and selling them on Amazon. Well, I obviously as if you're writing books or things like that, you don't always put your real name. So my best friend's name was Carrie, and I was pretty moody that day. And so there you got it. It was Carrie Moody. And that is why my email address is Carrie Moody Books. So that's where it all came from.
That's
So
awesome.
hopefully that just helps everybody out. Now you know who Carrie is. Heather's Carrie. I don't know who I am half the time. So yeah, we've all been threatened over this case. So um, anyway, we're gonna move right along from that. But I appreciate you guys all being here. Thank you as always. And Mary Jo Longnecker, thank you very much for becoming a new member. I did just hear that we were gonna probably have some pretty bad storms here after a little bit, so hopefully nothing cuts out on my end. If it does, I apologize in advance, but it should be okay. So
To highlight Jessica's for me. Jessica, are you asking to change your name? So it's what's funny about that is the level of protection is a serious thing because we've had a lot of people come through saying, I have information, but I don't want you to use my name. I don't even want you to say what I've said. I want you to put it in different words for me because I want to remain anonymous. So protection is a very real thing. And I think a lot of YouTubers out there can understand that.
Oh, definitely. I mean, it's not happened to me, but I've seen so many YouTubers like get fake CPS calls and CPS is showing them up, 10 different times at their home for no reason. They're getting swatted. I mean, horrible things that people do and do go real life. So you do need to be careful about that. I would even go so far to say as I know that things have been screenshot in groups and shared
Mm-hmm.
to others, and if you're using your real name in a group, I don't know, maybe I don't know. I don't know that I would do that because it seems that there are some people out there that enjoy screenshotting and taking your words and twisting them and making it out to be a bad thing and then
Mm-hmm.
harassing. So maybe consider that as well. Yeah, yep, said I use a dummy, Facebook always.
I feel
Definitely.
that. Yes, Hal, please let me know what you're going to change your name to. That way we can find you. That would
Yes.
be awesome.
Yes, because we like Hal. We like Hal. We need to know who you still
Well,
are.
and that's the thing too, how and there's a whole litany of our people that come in here and they chat with us and they listen to us and we've got such a great group of a great chat. We just don't have any issues in the chat. And so it's not a reflection of anybody that comes into the chat and
No.
engages with us. It's just things that happen as it turns out in this industry. It's kind of par for the course. And I didn't know I was signing up for that, but okay, we can do it. I'm cool. We'll make it work. I don't
Yeah,
think I would I
two
think I
and
would
a
use my
half
name.
2.5 years on YouTube, I've never run into any issues with anybody. So, there's that. But here we
Yeah.
are. there's issues, so we're just kind of getting that out in the open and just letting you guys be aware, you know, of the names that you're using. So,
Agreed.
all right. So let's get to it. Today was um, another hearing. So they had a status hearing today. Um, all 5 suspects appeared in court for that status hearing. Now, there was certain things that were addressed. The judge did deny. Tifany had requested to have the search warrant sealed in the case. The judge denied that request. However, he did order a motion to withhold the full medical examiner's report for an extended amount of time, as well as issued a gag order in the case. And we will go over both of those with you guys. Tad does have a private attorney. So, before I had said, it doesn't appear like it. Looks like, she's on the OIDS, whatever, indigent. Yeah. But
Indigent,
it
yeah.
does appear that Tad did indeed hire an attorney. So I take that back. But he's the only one that has. I wonder how Tifany as a girlfriend feels knowing that Tad's hired this attorney and here she is with her court appointed, but looks like she's got
Right.
pretty good representation though.
Right.
Um, so let's go. Oops, let me go back to that real quick. So I haven't used slides on here before, so I'm gonna try to figure this out while we're going at it. And let me so there's just a couple of real quick clips that I wanted to share. Let's see. Oh, it helps if I push the right button.
It might.
There we go. Okay. So this first video is on the gag order that they had done. So let me share that.
Accused of murdering 2 Kansas women in Texas County appeared in court this morning. News Channel 10 Sydney Batzloff is at the hearings and has the very latest.
All 5 suspects appeared back in court this morning for a status hearing. We got to see each suspect with their attorney. Out of the 5, only one, Tad Colum, hired his own attorney. All others are with the Oklahoma Indigent Defense System. Now, as far as what happened inside the courtroom, we heard several arguments from attorneys on several different motions. As far as what happened with the judge, he did deny that the search warrants be sealed. As far as what he ordered that the medical reports be withheld from the public for 6 months at this time. He also did order a gag order, meaning that law enforcement, counsel, everyone involved in this case isn't going to be able to talk to the press just because of the national attention that it's getting. The reason for that is to make sure all suspects have the right to a fair trial. He also ordered 3 discovery motions, meaning that the defense will be allowed to have access to that evidence and be able to inspect it for themselves. The next court appearance is scheduled for Wednesday, June 19th at 9 in the morning. And we did hear from attorneys today that they would like each suspect in the courtroom at the same time to be able to hear all of those arguments. The judge says they're going to take that into consideration, but again, they still have to think about security with this case. We'll continue to follow this story as it develops. Reporting in Guyman, Sydney Batzloff, News Channel 10.
So they want the next hearing, they want all 5 defendants as well as their attorneys to be in the courtroom at the same time.
Mhm.
That's a really small courtroom, so that should be interesting. And then the next quick clip as well that I wanted to play is it's from News Nation, and let me grab that. And then those are, believe it or not, the only 2 clips that we are going to play tonight. This one.
In about 30 minutes, they are accused of killing Veronica Butler and Jilian Kelley. The pair vanished on March 30th on their way to pick up Butler's 2 kids for a supervised visitation. Their bodies tragically were found more than 2 weeks later in a rural area of Oklahoma. The suspects in the case each charged with first-degree murder and kidnapping. One of them, Tifany Adams, is the paternal grandmother of Butler's children. The two women had been in a bitter custody battle over the little girls. Trial attorney Karen Conti joining us now to talk more about the case. She's the author of the new book, Killing Time with John Wayne Gacy. Welcome back as always, Karen. What are the challenges for attorneys on both sides in a case like this when you have 5 suspects in a double murder?
Well, you're going to see probably some of the defendants turning on each other and blaming each other. And you're going to find the prosecution looking at the least culpable of these 5 people and trying to get them to turn on the others. And so everyone is going to need a separate attorney. Everybody's going to have a separate defense here. And it's going to be very, very complicated.
Based on what we've seen publicly so far in court documents, the paternal grandmother, does she seem the most culpable? Does it seem like the finger pointing will start with her?
It probably will, just because it seems like from what I've read in these affidavits, which are very detailed, that there was a plan. This plan was in place for a long time. And in fact, these defendants made some efforts to kill the mother before by using some sort of weight and throwing it into her house, and it was unsuccessful. So my guess is that the grandmother is going to be deemed to be the ringleader in this matter. And, you know, it's interesting because grandmothers, there's a kind of an obsessed grandmother syndrome, maybe not officially, but some of these grandmothers become very, very adamant that they want custody of their grandchildren, and they become emotionally distraught when they're not. And my guess is that we're going to see a little bit of that when the evidence comes out.
You practice family law. I'm sure you've seen some pretty contentious custody battles play out, maybe not quite to this level.
I will tell you this. People think that criminal law is the most dangerous when it comes to defendants and lawyers and judges, but it's not. It's family law. Why? Because in criminal law, usually the criminals are locked up or they're handcuffed. In family law court, everyone's walking around. It's a very dangerous place. Judges have been murdered. Lawyers have been murdered. And, you know, I just read the statistics last year, 950 children died during custody disputes. So even the children are at risk when it comes to these cases.
Yeah.
Emotions are high, and people feel like they have no other options than to murder, and I guess in some cases.
Yeah, it's personal. And in this case, a 16-year-old daughter of Twombly gave investigators the potential damning evidence in this case that led to their arrest. How key will she be to the prosecution's case?
There's a lot of evidence here. Other than that, I mean, there's cell phones, there's texts and emails, there's forensic evidence. So there's going to be a lot of that. But this is going to be key because apparently, according to the affidavit, one of the defendants told her what they were going to do and told her to clean up the car. So this poor girl, who now has both her parents in jail, is now going to be number one witness in this case. And that is going to be very unfortunate for her and put her in a very, very bad position.
The tough thing here, and Karen, we saw this the first time, 4 of the suspects.
It makes me so sad thinking about that she's going to be, you know, like the primary witness, really.
These 4 suspects, and you understand the emotion involved. How will the judge in this small community prepare for a case like this when it is so emotionally charged and these people are in so much pain?
Well, you saw the defendants when they were being brought into court, and they're all wearing bulletproof vests. So you know that they are very prepared for this. The police have also said that they are going to have a huge presence every time this case is in court. And you're going to see that. And my guess is that everybody who's on duty and some people who aren't on duty are going to be at that courthouse protecting everyone. Emotions are very, very high. And again, this is just such a tragic, just senseless murder. And, you know, it's in a small community. It's just a recipe for violence.
Death penalty in this case, Karen, how likely is that?
My guess is that we're going to see the death penalty. Oklahoma has used the death penalty pretty frequently compared to other states, and they're not afraid to use it. And my guess is they're going to choose at least 1 or 2 of the defendants to seek the death penalty, and maybe by doing so, get some sort of plea in exchange for life in prison.
You're right, senseless. This is just one of the worst cases. Feeling for both of those families. Karen Conti, as always, appreciate your perspective. Thank you for watching. Go to newsnationnow.com to find News Nation.
All right. What are your thoughts on that, Tara? I'd watched it a couple times earlier. I don't know if you'd seen it yet today.
No, I hadn't seen it yet. There's um, so the gag order is interesting to me because that just I actually had somebody reach out to me today asking if that applied to YouTube channels or other social media platforms, and it does not. When you read
No.
through the court documents, it doesn't apply to anything that it only applies to those who are directly involved with the case. So the attorneys, the defendants. So that's to say, if Paul, Cora, Tad, any one of them wanted to roll in the other one, they could talk to their attorney about it. They could keep it on the legal aspect, but they can't go anywhere else with it. So they couldn't talk to a reporter or anything of that nature. I think what grabs my attention the most is they won't allow the Emmy records to come through. Those are sealed down.
Right.
So that tells me a lot right there.
And yeah, Mama Moon, News Nation does.
Yes.
Unfortunately, all of the mainstream media does mess up facts. I mean, like, I understand because, Tara and I've made, I wouldn't say mistakes, but what we thought was valid information at the time that later has turned out, differently. And so I'm sure that happens with the news media just as much as it does with us. But they've also messed up like really, you know, like names and whose kids
Mhm.
who and things like that they shouldn't be messing those kind of things up, I don't think. But
Correct.
I have to give them credit because they have been covering this case from the very beginning, and they're one of the very few. And the national attention that it got, even international attention, is a good thing. I think it is a very good thing.
Mhm.
And yeah, the daughter just needs to be brave, Amy said, and yeah, she certainly has been. She's well protected, no doubt. And
What a
yeah,
burden to bear, though, at that age.
gosh,
What a huge responsibility to have forced upon you by the people you're supposed to trust. I think that really, that I just have
it's sad.
such an issue
Anytime I,
with
like,
that.
start to feel bad for Cora for any reason, I'm just one of those people, I always try to, like, look at, well, what got her there or what like, did something happen to make her get involved? Like, that kinda
Mhm.
thinking, and every time I think like that, then I think about the fact that she asked her daughter to do that
Yep.
cleanup for her, and then all of that, any kind of empathy that I might have for her kinda goes out the window real fast.
Yeah, it does for me too, and I don't know, there's so many of us here that are parents, and I cannot imagine talking there's some conversations I have with my children present. 2 of my children are adults, 1 is still a minor. I can't imagine having those kind of conversations in a home.
Oh my gosh, no way.
Even if you thought your minor child wasn't within earshot or was asleep in their bedroom, you would still take that somewhere else, I would think, but in some of the things that we have learned, the overwhelming theme is that superior intelligence, despite the delusion, is not present with these 5. At least it doesn't
Right.
seem to be.
Gotta Love Fireworks has a really good question. Should Cora's daughter be allowed to testify behind closed doors, have it videotaped and played at trial, or is that reserved for younger witnesses? I don't know that answer. I would hope that it could be videotaped. I'm not sure. With her age, I'm
God.
not really sure. Hopefully somebody in the chat will know the answer or they'll see the replay and help us out. I know we have some, really good attorneys in our group and stuff, so
Yeah, that would be
hopefully
great to
somebody will
know.
let us know because that's a great question that I really hadn't even thought of that. But I know that many times they do allow videotaping of it, and it's gonna be a lot of pressure on her, and these are her parents
Mhm.
and other people she was very close to as well. Hopefully, they allow that, and they don't make her sit in the courtroom and face it. Um, she's a little bit younger, but, um Cora's daughter is, I mean, but Gannon Stout's case, they did have, Letitia's her daughter testified because she was over 18, though. So, I don't know
Right.
how that will work out.
That would be very interesting, especially if that takes a court document or a court order to there's Yep says that if cameras are ever allowed, which they may not be in the case, she shouldn't be shown, but there's no closed door
Right.
testimony. Yeah. So I mean, I believe Cora's daughter is 16 or 17. Like she's
Yeah,
an
she's
older teenager.
16. Mhm.
Someone instilled her morals, and maybe the
Yeah.
choice she made. I tell my children, I tell folks all the time when they comment how great my kids are and how great my parenting was. I was just an example. They had to make the choice. So it sounds like Cora's daughter made a different choice than maybe what she was exampled. I don't know. It's hard to believe that they were upstanding citizens. I mean, I've heard great things about them, but I've heard some interesting things about them too. So,
Right. And my understanding is that Cora's daughter, her father, she does have a very good father and stuff. So,
mhm,
um it's just all hard telling. So,
I'm
all
sure.
right. So back to that. Tad is the only one with private attorney, so I'm correcting the information I'd said previously. I don't know if we said in a live or in a group, but whichever.
Mhm.
He did actually hire the attorney, so I can only imagine Tifany, girlfriend Tifany, she's probably steaming mad now. Um, Wrangler. Okay, so let's go back here a minute. Let's not go to Wrangler quite yet.
Okay.
Let's go to the motions. And let me get those pulled up. And Tara, I'm going to let you read this first one if you don't mind. I make it a little bit bigger. This is Tifany's motion to seal warrants. This was filed on May 10th, so just last week. And hopefully that's big enough for everybody to be able to see. I can
Okay.
let's see. There we go. Is that better? Does everybody see that pretty good, I hope?
That looks better. You'll have to scroll up for me as I go.
Okay, I can handle that.
There we
We've gotten
go.
good at that. All
That
right.
looks great. So, what we have here is a motion to seal the warrants. Now, these are the affidavits that led to the arrest of these five. So, this is what she's trying to get sealed. When they say sealed, they don't want them available for public access. Okay, so comes now the defendant by and through counsel Mitchell S. Solomon, Raven S. Seeley, Alex Richard, and Maya Hansen, Oklahoma Indigent Defense System, Norman Capital Trial Division. The defense seeks an order to seal the search warrants and their supporting documents in this case and Texas County cases, and they're listed there. I'm not going to go through all those. This order is necessary to ensure a fair trial, prevent undue witness influence, and avoid excessive publicity that could further taint the jury pool and prejudice the case. The disclosure of the sensitive information contained in the search warrants can imperil constitutional rights guaranteed by the 5th, 6th, and 14th Amendments of the United States Constitution. Witnesses and prospective jurors' exposure to unproven allegations in warrants and supporting documents threatens the integrity of the judicial process. Although law enforcement agencies generally must make the disposition of warrants available for public inspection, the Oklahoma statutes outline the court's authority to seal records, including search warrants and their supporting documents. And there's an Oklahoma statute that backs that up there. So we move on to the witness and jury pool contamination. Sealing the warrants and their supportive documents will help protect against tainted witness testimony and a tainted jury pool. Historically, Oklahoma courts have addressed these issues through two mechanisms: witness witness sequestration and change of venue. Witness sequestration, deeply rooted in common law, aims to keep witnesses from being exposed to others' statements. Witnesses are separated in order to detect falsehoods and by exposing inconsistencies. Change of venue requests stem from concerns about pervasive media influence on the jury pool. And we've got a state case that's mentioned there. Prejudicial pretrial publicity certainty can taint a jury to the extent that a fair trial is denied the accused. And then another case is mentioned there. The same problem with these mechanisms seek to avoid a rise with unrestricted public access to warrants and supporting documents. With unrestricted access, anyone, including media outlets, witnesses, and prospective jurors, can read the unproven, untested allegations and statements made in warrants and supporting documents. Consequently, multiple avenues exist for witnesses to encounter statements and alleged facts of which they have no independent knowledge and for jurors to be improperly influenced. Such exposure casts doubt on the overall integrity of the ongoing investigation and any ensuing trial. Death is different. These concerns are all the more troubling in a possible capital case. Although no bill of particulars has been filed here, the defense must be conscious of that possibility and must handle the case accordingly. The United States Supreme Court and Oklahoma Court of Criminal Appeals have recognized that death is different. We've got a couple more cases mentioned there. The Supreme Court has repeatedly written about the qualitative difference between capital and non-capital cases. The court has stressed the acute need for reliable decision-making when the death penalty is at issue. And then more court cases mentioned. It has addressed the unique nature of the death penalty and the heightened reliability demanded by the Eighth Amendment in the determination whether the death penalty is appropriate in a particular case. And more cases are mentioned. So we scroll down, we're going to read that. The death penalty is, we scroll for me, Carrie. Can you scroll that for me? You probably are scrolling it for maybe just a little bit of a lag. Oh, there we go. So the penalty of death is qualitatively different from a sentence of imprisonment, however long. Death in its finality differs more from life imprisonment than a 100-year prison term differs from one of only a year or two. Because of that qualitative difference, there is a corresponding difference in the need for reliability and the determination that death is the appropriate punishment in a specific case. And we've got a case mentioned there. Because of the exceptional and irrevocable nature of the death penalty, Justice O'Connor in 1982 emphasized that our system of justice must go to extraordinary measures to ensure that the prisoner facing the possibility of being sentenced to be executed is afforded process that will guarantee, as much as humanly possible, that the sentence was not imposed out of whim, passion, prejudice, or mistake. More cases are mentioned there. These extraordinary measures must be taken at both stages of any capital trial, and again, a case is mentioned, to ensure that the death penalty is indeed imposed. And we'll scroll down. Love technical lags. They are so much fun. Imposed on the basis of reason rather than caprice or emotion. We have invalidated procedural rules that tended to diminish the reliability of the sentencing determination. The same reasoning must apply to the rules that diminish the reliability of the guilt determination. And then more cases are mentioned. In capital cases, the finality of the sentence imposed warrants protections that may or may not be required in other cases. And the cases there are mentioned. Here, sealing the search warrants and supporting documents is necessary due to the unique circumstances of the ongoing proceedings and the higher stakes implicated in potential death cases. Moving on to media attention and a small community. Concerns about witnesses and the jury pool are not mere speculation. The case has already received widespread media attention and charges have been filed in a relatively small community. The case has garnered attention from local, national, and international media outlets. And we're going to hop over to the next page. It's still lagging for me just a little bit, but it's fine.
Yeah, there's always like a 5-second lag, so sorry, guys.
No, yeah, it's awful. It's a part of the tech. There are TikTok videos and podcast episodes discussing the case, some dedicated solely to dissecting the arrest warrant affidavit for Ms. Adams. This coverage creates a significant risk of prejudicial pre-trial publicity. Sensational and provocative statements, including evil mother-in-law lures the two moms to their deaths, and killer granny suspect by sources like Nancy Grace, undercut the presumption of innocence. I'm having a hard time reading
I'm
that.
sorry. Yeah.
Because it's interesting how they put that in big capital letters, but
Killer Granny
suspect
by Nancy Grace. Dang
Nope.
that Nancy.
Oh, goodness sakes. The relatively small size of the community where the alleged crime was committed increases the likelihood of widespread knowledge of the case among residents, personal relationships with those involved, and strong community sentiments that could impact the fairness of the trial. For a jury trial in a county court in Oklahoma, the jury pool is composed of county residents who are 18 and older and who hold a current driver's license or ID from DPS. And there's an Oklahoma statute there that says that. The number of people within that 20,371 who are qualified for jury service is even lower. Sealing the warrants, and I feel like we need to play that Jeopardy music while we're scrolling and waiting. So sealing the
I
warrants.
know. I was looking at these. I was looking at the names that they have mentioned here. So they have True Crime Mama
Oh,
on
nice.
TikTok. Annie Elise. Shout out to Annie. Another True Crime Mama on TikTok. Nancy Grace. Oh, that's funny. All right.
Oh my
Okay,
goodness.
there. Hopefully that's where you need to be. I'm sorry.
No, you're good. But it's interesting because it goes to show just
Mhm.
how much social media, how powerful social media is. So
Yeah.
sealing the supporting documents mitigates the risk of influencing potential jurors and preventing premature judgments based on incomplete or biased information circulated by the media. It also ensures that witness testimony remains untainted by exposure to extrajudicial information, thereby preserving the integrity of the trial process. So, moving on to the conclusion. Wherefore, the defense asks this court to order that the search warrants and supporting documents in this case and Texas County cases, which are mentioned there, be sealed and kept from the public for the pendency of this prosecution. The quote unquote facts in circulation, which come from unsupported, unsubstantiated allegations in the warrants and supported documents that have already been made accessible to the public, threaten Ms. Adams' rights to due process and a fair trial by a fair and impartial jury under the 5th, 6th, and 14th Amendments and corresponding portions of the Oklahoma Constitution. Maintaining the confidentiality of these materials is crucial to protecting those rights, ensuring impartiality, and safeguarding the judicial process. Respectfully submitted, and the attorneys are going to be listed there. So that is there's a certificate of service, but again, that's just the legal stuff. So
yeah. So if you wanted to, if you have anything you want to discuss on that, go right ahead on that, on the last one, and then I'll go over this one for us.
And is that's the prohibit extrajudicial
Yes.
Holy crow, words are fun tonight. Extrajudicial statements.
Yeah, this is basically the gag order one.
Yeah, and these are interesting how this turned out. So I'll hold the comments that I have until you read this one because they go together.
Okay. All right. So oops, wrong one. I have a lot of files pulled up here. All right. So again, this was Tifany's filing on May 10th. Motion to prohibit extrajudicial statements. Comes now the defendant buying through the counsel Mitchell Solomon, Raven Seeley, Alex Richard, and Maya Hansen from the OIDS system, Norman Capital Trial Division. The defense requests a gag order in this case. Based on previous conversations with all counsel, the defense asserts there are no objections to this request. This case has already received extensive local and national coverage. And then it goes on to talk about all the coverage that it's gotten. The Fifth God's Misfits member charged with murder and death, the Oklahoman. Oh my. So all of those, basically the things that we've all seen. Brian Inton's mentioned. And let me keep scrolling
Anybody we know?
through. Yeah. Not yet.
Not yet.
I
want to see if we become court document famous.
Yeah. So, and then
Right?
it lists all of the, so BBC, CNN, News Nation, People.com, USA Today, AP News. I mean, yeah, it's gotten a lot of attention. Prosecutors say Tifany Adams told investigators she was responsible for Kansas mothers' deaths. Yahoo News, April 19th of 24. Because of the extensive media coverage, damage may have already been done in regarding to tainting the jury pool and the venue. Still, a gag order at this point would help mitigate continuing media coverage, or at least it would prevent law enforcement, court personnel, and counsel from contributing to that coverage. Without a gag order in place, there's a reasonable likelihood of prejudice. Reasonable alternative measures. Now, listen here on this line right here. Reasonable alternative measures, including a scrutinized jury selection process, cautionary instructions, change of venue is brought up in this. Continuance and jury sequestration might ease the potential of prejudice, but these measures cannot ensure a fair trial here. The defense therefore asks the court to order that law enforcement personnel, court personnel, and counsel for all parties, to include parties in this case as well as Texas County cases, be prohibited from making extrajudicial comments to news media, reporters, and or media representatives by any means and in any manner or forum reasonably likely to be publicly disseminated or published through news media when such statements address opinions regarding the facts or the merits of the charges or any anticipated defense to the charges, any opinion, evidence, information which relates to any past hearings or rulings made by the court in any of these cases, any opinion, evidence, or information which relates to any future pretrial hearing or possible anticipated ruling by the court regarding any factual or legal issues which is or are material to the cases, and or any opinions, evidence, information, or other matter which may be introduced at or during any trial in any of the cases. The defense asks the court to specifically exclude from this prohibition general statements by the accused as to their innocence and any statement which relates to scheduling or advising of the dates and times of court proceedings in these matters. The defense makes these requests based on Ms. Adams' rights to due process and a fair trial, including trial before a fair and impartial jury under the 5th, 6th, and 14th Amendments of the United States Constitution and corresponding provisions of the Oklahoma Constitution. And then just certificate of service to all the attorneys. So that gag order was put in place. But as you can see, that is going to be related basically to their attorneys, anybody that works in law enforcement. My guess, it might also include those on the witness list. Would you think, Tara? Can't you hear me?
She can. She's just muted because that's what
Okay.
I do. I shut my own self up sometimes. Yeah, I think that's going to apply to the witness list and the defendants, anybody who's involved with this case at that legal level, because you don't want anybody talking about it. They're trying to protect what I use this term so loosely in regards to this case, whatever integrity they think is left.
Yeah.
And I don't think there is any. So now the gag order, it went through. That was granted, no?
Yeah, that was granted.
But the
Yeah.
sealing of the documents, the sealing of the warrants was not granted. Is that
Correct.
right?
Correct.
So, and I'm going to post this question to the chat. Why do you think the warrants were not sealed, but the gag order was put in place? What do you guys think that means? Some of you are legal beagles. You're going to know and be very well informed on it. Others may have a really great way of thinking about the strategy on that one. Because she's a hee-haw, I get that. Oh, I didn't see that, but that's okay. There's a lot. Oh, I get that, but it's ridiculous because she's in control of her attorney and telling him what she wants. Well, yeah, but she's the client, right? They have the control. And that's how many times have you seen or heard? And it's TV, right? But you see a client saying, "I want to do this." The attorney's like, "That's a bad idea. No, you should not get up there and defend yourself. No, you should not do this." And somebody's narcissistic enough to go ahead and do things that impact their case negatively. So she wants to control it, and she's not that high pine needles. I actually got your name right this time. If she wants to control it, and if she keeps up with her antics the way she has, I don't think it's going to get her anywhere. But I'm glad that those search warrants were not sealed. I don't think they need to be. Not that that would do any good. They're posted on
Right.
social media,
Yeah.
which is probably why the judge was like, I wasn't there, but I feel it wouldn't surprise me if the judge thought they're already out there, folks. Like, I've seen them out there. Well, I don't know why you want me to. If I seal them, somebody will go get them from somewhere else. So I bet you see a unites request from all attorneys in the future, and that will probably be taken under advisement more by the judge. Since it was just her, I think the judge was just hesitant. Perhaps.
Yeah, and Tad's, we have Tad's new documents filed today as well, and in his, they actually referenced Tifany's filings. So that was kind of interesting.
Lisa, did I say search warrants? I meant arrest warrants. That's on me. I'm glad she brought that up. I don't know about the search warrants. Do we have? I don't think I've seen them. I've just seen the arrest. The arrest warrants are the ones I've seen, and I wanted to see those, so I went after those.
Yeah. All right. And then the next and final one for Tifany that was filed last week, that was the motion to preserve evidence. And I believe this is a pretty short document. Let me see here. Okay, maybe not so short.
Hal, I appreciate your comment that she's a terrible planner and bad track record.
Yeah, she is.
That's been proven.
I saw that.
That's been absolutely proven.
So this again was filed May 10th. We didn't already do this one, did we, Tara?
Motion to preserve evidence? I don't think so.
No. Okay. So this was filed May 10th on behalf of Tifany. Comes now the defendant by and through her counsel. The defense asked the court to order that the state and any agent of the state be prohibited from releasing evidence related to this case that is currently in the possession of law enforcement. The defense requests that this order apply to evidence in law enforcement possession, whether or not law enforcement or the prosecution currently believes the evidence is material or admissible in court. This order is necessary to prevent the improper loss or destruction of evidence. So the way this was explained to me is this is just kind of like normal. Like, this filing is kind of a normal kind of filing. It's you're not going to misplace or destroy any kind of evidence kind of thing, basically, is what it boils down to. But on April 17th, the court ordered that Ms. Adams receive appointed counsel. On April 24th, defense counsel filed an entry of appearance, a motion to inspect and examine the physical evidence and prevent the destruction or consumption of samples without notice, and the defendant's motion for discovery. Since filing the motion for discovery, the defense has received no police reports or any other piece of discovery. The defense has been informed that state agents possess items that may have evidentiary value, and the state has been asked to release these items to their owners. The defense objects to such release and to any action that fails to properly preserve any evidence that may be relevant to this case. Like, the first thing that comes to my mind would be, say, a cell phone or something like that, where they take the cell phone, they download all the information, they get the cell phone back. Like, that's just where my mind goes. I don't know what all they're talking about here, but so the defense asked the court to order that items recovered by state agents in relation to this case remain in the state's custody, and that the items be preserved in the same or substantially the same condition in which they were initially identified or recovered by state agents. The defense counsel, the defense investigators, and defense experts must be able to inspect, analyze, and or test this evidence while it's in the same or substantially the same condition as when the state agents identified and or took custody of the items. Only the immediate identification and preservation of the evidence will prevent its improper loss or destruction. You want to go from there for me, Tara? Let's see. Discovery and
Yes, I
potential
can.
exculpatory evidence. Okay.
Let me. If you hear the mutts in the background, just ignore them and they will
That's
go
all right.
away. And there is I just messaged you. There is a mod in the group that needs to be updated.
Okay.
So we are at the defense and potential exculpatory evidence. So in the defense motion for discovery, page 4, item number 8, the defense requested the opportunity prior to trial to examine, inspect, scientifically test, and receive copies of any item of physical evidence which was seized or obtained, which belonged to the defendant, the victim, other suspect, or any other person which was collected, seized, or provided to law enforcement or the state in regard to this incident. The request includes all items in the state's possession, regardless of whether the items were seized legally or illegally, including but not limited to any and all books, papers, documents, pictures or videos, electronic devices, items of physical evidence, clothing or other paraphernalia, any weapons or objects which may be suspected to be a weapon, or other tangible items or object which in any way relates to the charge filed against this defendant. In addition, access to any buildings or places owned or controlled by the state which were involved in either the investigation or preparation of this case. And there's a case there that's mentioned to support that. In the same motion on page 4, item number 10, the defense requested, and you'll have to start scrolling up for me when you have a moment, because lags are so wonderful. They're so great. I love lags. The opportunity prior to trial to examine, inspect, and receive copies or samples for scientific testing, analysis, comparison, or any evidentiary or forensic item which was seized or collected from the defendant, any victim, or other suspect, or any other person which is in possession of the state or law enforcement and relates to this incident. This request includes, but it's not limited to, all items in the state's possession, regardless of whether the items were seized legally or illegally. This request includes copies of fingerprints, palm prints, handprints, shoe prints, tire tracks, hairs, fibers, projectiles, or ballistics, trace evidence, drugs, or medications. Oh, I can't see. Go ahead and scroll up for me. The comment section. Every time you bring a comment up, it can block my view, but to keep them going. Shiv, hairs, fibers, projectiles, ballistics, trace evidence, drugs or medications, blood, saliva, hair, clothing, DNA from, oh, you went too far. DNA processes or analysis, and any other items of physical evidence collected or taken from the crime scene or scenes, or any other location involved in any way in the investigation of this crime, including any and all of the defendant's property that was seized or collected from him by law enforcement or the state. And so we have a state law there, or a case that's mentioned there. In the same motion on page 8, item number 40, the defense requested any and all information or materials in the prosecution's possession or control, or which could be acquired by due diligence from any law enforcement agency by the prosecution that might tend to exculpate the defendant or mitigate punishment in the event of a conviction. We've got a couple of case law there. In the same motion, page 9, item 41, the defense requested any and all information that could lead to the discovery or evidence that tends to negate the guilt of the defendant as to the alleged crime, or would tend to reduce punishment therefore, which evidence or information is in the possession or control of the prosecuting attorney or any member of his staff or any representative of law enforcement official or agency, including any person who has participated in the investigation or evaluation of this case, who reports either regularly or in this case particularly. This request includes, but it's not limited to, any evidence that establishes or supports any mitigating evidence or tends to negate or rebuke any aggravating circumstances the prosecution alleges. We have case law there. The defense now reiterates these requests. If any item is to be used as evidence against Ms. Adams at trial, the defense must have the opportunity to examine the evidence beforehand. A defendant has a constitutional right to examine the evidence which will be used against him at trial. To enforce this right, the state and its law enforcement representatives must provide a defendant the opportunity to examine that evidence, preserving sample evidence for testing where appropriate. We've got case law mentioned there, and a lag to hold me back. Regardless, though, of any assertion about whether the items in question can or will be used at trial, the items may contain or lead to exculpatory evidence. Due process requires the state to disclose exculpatory and impeachment evidence favorable to an accused, and several state laws are mentioned there, or state cases, I should say. And we're going to scroll up because, moreover, as discussed further below, the defense fails to request that the items be preserved, fails to examine the items, or fails to learn of exculpatory evidence. Counsel will have, and we're going to scroll up. Lags are great. Counsel will have, oh, for goodness sakes, it's like it jumps when it finally catches up. Counsel will have rendered ineffective assistance. And then there's case law mentioned there. So death is different. So we're going to move on to this section where, although no bill of particulars has been filed here, the defense must be conscious of that. Insert lag. They wouldn't use it if it didn't have a lag. Conscious of the possibility and must handle the case accordingly. The United States Supreme Court and Oklahoma Court of Appeals, OCCA, have recognized that death is different when we've got case law after case law mentioned there. The Supreme Court has repeatedly written about the qualitative difference between capital and non-capital cases. The court has stressed the acute need for reliable decision-making when the death penalty is an issue. More court case, court law, case law. It has addressed the unique nature of the death penalty and the heightened reliability demanded by the Eighth Amendment in the determination whether the death penalty is appropriate in a particular case, and more case law follows there. So the death penalty is a qualitative different from a sentence of imprisonment, however long. Death in its finality differs more from life imprisonment than a 100-year prison term differs from one of only a year or two. Because of that qualitative difference, there is a corresponding difference in the need for reliability and the determination that death is the appropriate punishment in a specific case. And we have case law mentioned there. Because of the exceptional and irrevocable nature of the death penalty, Justice O'Connor in 1982 emphasized that our system of justice must go to extraordinary measures to ensure that the prisoner facing the possibility of being sentenced to being executed is afforded process that will guarantee, as much as is humanly possible, that the sentence was not imposed out of whim, passion, prejudice, or mistake. Case law follows there. The extraordinary measures must be taken out of both stages of any capital trial. So we move on to page 6. And we have a lag. You guys are used to the lag, right? Like it gives you an opportunity to take a drink or go grab a drink. There we go. So to ensure that the death penalty is indeed imposed on the basis of reason rather than caprice or emotion, we have invalidated procedural rules that tended to diminish the reliability of the sentencing determination. The same reasoning must apply to the rules that diminish the reliability of the guilt determination. Insert case law here. In capital cases, the finality of the sentence imposed warrants protections that may or may not be required in other cases. Case law follows. So effective assistance of counsel. When analyzing another counsel has been effective, courts look at, among other things, whether the representation satisfied an objective standard of reasonableness. Under prevailing professional norms, case law follows. And the ABA's guidelines and standards help courts to gauge professional norms. The guidelines are not aspirational. Instead, they embody the current consensus about what is required to provide effective defense representation in capital cases. ABA guidelines, Guideline 101, History of Guideline. The U.S. Supreme Court has repeatedly referred to the ABA guidelines and standards in determining whether counsel's performance satisfied an objective standard of reasonableness. Several case law follows there. The defense recognizes, as the U.S. Supreme Court recognized in Padilla, that the ABA guidelines and standards are not inexorable commands. We have case law there, or at least a reference to a case law. But as the Supreme Court has further written, they may be valuable measures of the prevailing professional norms of effective representation. We can go ahead and scroll up. And the Supreme Court has long referred to them as guides to determining what is reasonable. We've got case law there. Notable here are the following ABA guidelines and supporting material. These guidelines apply from the moment the client is taken into custody and extend to all stages of every case in which the jurisdiction may be entitled to seek the death penalty, including initial and ongoing investigation and pretrial proceedings. Counsel at every stage have an obligation to conduct thorough and independent investigations relating to the issues of both guilt and penalty. The investigation regarding guilt should be conducted regardless of any admission or statement by the client concerning the facts of the alleged crime or overwhelming evidence of guilt. Because of the possibility that the client will be sentenced to death, counsel must be significantly more vigilant about litigating all potential issues at all levels in a capital case than in any other case. Accordingly, in order to provide constitutionally effective assistance, defense counsel has a duty to thoroughly investigate the facts and the law relevant to plausible options in both first and second stages of this case. Lots of case law follows there. Conclusion. Wherefore, the defense asks this court to order that the state and any agent of the state be prohibited from releasing any evidence or item related to this case that is currently in the possession of law enforcement. The defense further asks the court to order that all such evidence and items be preserved in a manner that will allow defense counsel, defense investigators, and defense experts to examine them in the same or substantially the same condition in which the state agents initially identified and or collected them. The defense asks the court to grant this motion to safeguard against the accidental or intentional loss or destruction of any evidence that may be useful, whether or not it is ultimately admissible to support Ms. Adams' constitutional rights. The defense makes these requests based on the rights to due process and a fair trial, effective assistance of counsel, and freedom from cruel and unusual punishment under the 5th, 6th, and 8th and 14th Amendments of the United States Constitution and corresponding provisions of the Oklahoma Constitution. Outstanding. It's so hard, right? You read these things.
Shoot, so that was a mouthful, wasn't it?
Which is why you had me read it. So
Yeah.
these kind of things are hard to read. And we have to remember that everything's alleged, right? That's the irritating part of all of this. Everything's alleged crime, alleged victims, alleged perpetrators. Because, and this is one of the things that I would argue, open-mindedly argue with someone, that everybody's guilty until proven innocent. I kind of wonder what happens if we are innocent until proven guilty, but what if we did that in reverse? What if we were guilty until proven innocent? How would this look and work then? It's hard to stomach these kinds of things, and having the information that we do, seeing the things that are out there, the arrest warrants, hearing that Tifany Adams has taken responsibility or that Paul Grice confessed, and these kind of things. It's just amazing that we have, it's really sad that the perpetrators, the arrested, have more rights at this point than the family, friends, and even the victims in this case.
Yes. And I think somebody asked a question earlier regarding the search warrants and the probable cause affidavits. And I did get a message. Let me try to kind of summarize it for whoever asked that question. Obviously, the search warrants are different than the probable cause affidavits. The search warrants, there'll be an itemization of all the items that were seized. And I asked, will those only come out at trial? And that answer is, in another case, they were able to obtain that file from the police department or sheriff's department, whichever it was, while the criminal charges were still pending. There was a protective order in place at the time, which would basically be like this gag order, meaning that even though the attorneys got a hold of those materials, meaning the itemized list of what was seized. They could not share that list of materials with anybody outside of the case that they were working with. And I said, so is that where the gag order could also apply here? And the answer is essentially yes. There are more or less probable cause affidavits that justify the search and or seizure. These details are likely what the defense once kept under wraps, which is why they filed their motion. So I don't remember who asked that, but that's a really good answer.
Oh,
Yeah, they did. And so Outright said, well, Granny sold the farm to prolong the death penalty.
what do you
And
mean
Lisa
on that
Kay,
one?
yeah, it's not hers to sell, it's in a trust. So she's got multiple sisters that she would have to go through to be able to sell that.
Well, there's a lot of land out there. If you go out
Yes.
and look, I mean, it lands in several different names. I know Tiffany has the mailing address of several pieces of property out there. I want to say she owns a couple, but to Lisa's point, she doesn't own enough of it to
Right.
sell it and do anything to help herself in this situation, which, yeah, it's such a mess. I wonder if the families will file civil suits as well. It would not surprise me.
No,
I
I
do,
sure hope so.
I bet they've been approached already, but I don't know how that works for you legal beagles out there. Do you have to have the criminal case first to strengthen or help the
The
civil?
civil.
I would
Right.
think so. There's a big case, O.J. Simpson, while he was found not guilty, civil court said, yes, you are, because the families went after him on the civil level. So that would
Yeah.
be interesting to know. But it's, yeah,
Yeah,
these
and
things
I think
are,
Riley Strain's family, Riley out there in Nashville, Tennessee,
yeah,
his family, I believe, I followed that case very closely, but I believe that they are also looking at filing a civil suit against the fraternity and the bar. So Lisa said you could
it's
do a civil anytime. It's a totally separate kind of thing.
okay.
And Connie said they should file civil. It doesn't take as much to prove guilt in a civil trial.
That's my understanding, but I'm not as good at the legal stuff. So I wanted to ask,
Yeah.
but so that, I mean, this whole thing, I'm the gag order, it doesn't surprise me, but here's the thing. We've got 20,000 in that group on Facebook, the Jilian and Veronica group.
Yeah.
20,000, which is just about the same population as Texas County or Cimmaron County. Can't remember which one is which when it comes to the population.
Well,
They're
that's
pretty close.
crazy to think of it like that, isn't it?
Yeah, it is, and so
Really,
what I
yeah.
just it blows my mind if you go through those, and somebody made the comment in a chat not too long ago about there's no way you wouldn't want to change the venue. There's no way you can go through all of those, and that's just one social media platform or just one social media group. There's several out there, so I'm not an attorney, but man, I would think I'd want to get the hell out of Dodge. So I'd get a fair trial and try to convince people, essentially manipulate them into believing we really didn't do this. We don't know who did. And oh, that's, it's all circumstance. I don't know. I'm really surprised that they think they get a fair trial there. But at the same time, given the amount of um, influence and negative influence at that Tiffany seemed to have, I can see why she'd almost want it there. Like she could, I don't know. I don't
Right.
know the threats personally. They've come to me by way of those who have been involved with them as far back as I think I've heard about one threat that went as far back as late teens, early 20s. So this sounds like an ongoing thing for her. I don't know.
Yeah, and another thing that I was told by somebody with good legal knowledge is that it's also a possibility they could bring in a juror pool from the outside and bring in
Really?
Sue Guyman,
You
which
can do that.
yeah, so
As a
they
taxpayer, I would say no.
that might be one of the things that they do
Oh
try
my
to do, but
gosh.
I just still I don't see how they could possibly get a fair trial out there. I mean, at
I
this
don't
point,
either.
you would have to be hiding underneath a rock to not know about the case and have a some kind of an opinion on it if you live out there in that area.
Well, I mean, that was in the court document. There's 20
Mhm.
some thousand out there, 21,000, and not all of them are registered voters. Not all of them are able to serve. So that, I mean,
Right.
I would love to see what that selection pool population looks like. Just the volume. Is it out of 20,000 are 7,000 voters, and of those, I don't know.
You have to get a couple hundred people at
Oh
least
gosh, can you
just to
imagine?
narrow a pool down to 60 some people. Yeah, I'm with Lynn. I wouldn't wanna be nope.
No.
They'd throw me out of there so dang fast
I
and be
would be
like,
like,
"Nope.
she's guilty.
Yeah,
Sorry.
you're not
She's guilty.
needed."
I've been on the Facebook too long. She's guilty. All of them are guilty.
And Pine Needle protagonist said, "I think they can sue at the same time as a criminal trial, but often lawyers will defer to and coordinate with the state or Fed as to not interfere with one another." Okay, good to know. And jurors don't have to have no knowledge. I think many people believe that you can't have heard anything to be a juror. Yeah, and that's incorrect. Like you can have heard about the case and stuff,
Right.
but you have to be able to say, I can sit here and listen to all the evidence provided to me and come to a fair decision.
Well, that's
But
the thing. That's where social media kind of it muddies the waters for the jury pool. Is
mhm,
you get several people to do a voir dire. I'm saying that incorrectly, and I speak some of my French crap and Latin stuff. But if they have put out any kind of comment or post that indicates where they lean at in the case, that's where my concern is. It's not whether or not they know about it. It's, have you engaged in a conversation that makes it look like you have a tainted opinion?
right.
Are you open-minded enough to be a part of this? Or, are you one of those that's playing the field and you're trying to get on that jury pool so you can be the one to say, oh, guilty? So
Mhm.
you say fair trial, right? And this whole thing is unfair. Two women lost their lives at the decision of five individuals. Doesn't matter who initiated the decision. Five had to make the decision to make this happen, and
Right.
they did a fair trial. So maybe keep it there, since none of us believe they can get a fair trial. Yeah, go ahead.
Right.
See what happens. Go ahead.
Yeah, and, Shayna, hopefully I'm pronouncing that right, jurors could also be bussed in from downstate, and yeah, that's my understanding too, is they could be brought in from another area. I don't know. I don't know how that'll work. So then the last document we have is another filing of TADs from today. And then we're going to move into some of the stuff regarding Wrangler,
Mhm.
his gun charges, how Kevin McIntire kind of played into that, and a little bit of some factual information regarding Kevin McIntire himself. And the reason is that, he is a state's witness. He holds
Yeah.
a very high position of law enforcement and has for a very long time. And so we're just going to kind of present the facts on that and then leave it to you guys to make your decisions. We're not going to make your decision for you. Is he a bad guy, good guy? That's not really what it's about. But we want you to have the information. So,
Yeah,
but
this
this is the final filing for TAD from today. This was from this morning. Motion to allow the defendant access possession of law materials provided by defense counsel. And it's not really that interesting, but it kind of is. Comes now the defendant by and through his counsel, Joy Miskell, or however you pronounce her last name, Miskell, and respectfully requests this court to allow Mr. Colum access to legal books and materials provided by counsel. Counsel for Mr. Colum mailed 3 law books through Amazon and directly to the Texas County Jail per their policy 2 weeks ago. The books were received by the Texas County Jail on Monday, April 29th. It was a criminal law handbook, federal rules of criminal procedure, and prudent jurisprudence. The Texas County Jail is refusing Mr. Colum access to these legal books provided by counsel. These legal materials will provide necessary information to Mr. Colum in order to properly assist counsel in his defense. So, wherefore, defendant prays this court order the Texas County Jail to provide these legal books to Mr. Colum immediately. So they tried to send him some law books a couple of weeks ago, and the jail allegedly is refusing to give him access to those.
I feel like it's too little, too late on the educational aspect of this.
Right.
I feel like you should have had that beforehand. Like, this is reactive versus proactive. Like, for crying
Definitely.
out loud, I get it. There's something to all this, right? He wants to help in his own defense. I don't know why he's got a paid attorney, but it's just like, good Lord. Like, yeah, just let him have his law materials. Let it cause problems. Because clearly, every time these folks get an inch, they draw back a mile. Ugh. Just kind of, I don't know. You hate to say the term dig their own graves because it seems so inappropriate, but that seems like because the death penalty is on the case, that seems what's happening here.
Yeah.
Ted Bundy loved the law library. Yes, he did, and he still screwed up. And it's, I think I've heard it multiple times. Liars will tell on themselves.
Yes,
People
they
who do
do.
bad things that do have some type of a conscience, even an iota of a conscience, will out themselves. They will put themselves out there without realizing they're doing it. And so, oh my goodness sakes. Law books. Let him
Well,
have
my
it.
guess is Tad thinks he's smart enough to read through the law books too as well.
I bet
So
Tiffany told him that.
Tiffany
Sorry.
probably told him. Yes, definitely.
I don't know the relationship. I'm making a joke on stuff I've
Right.
read on the Facebook before I get more threats and nasty grams on my that's just trying to lighten the if y'all know me, then you know. If you know,
Tad
you know.
wasn't pro se, he was pro out the window. So moving to Wrangler. Okay, so this is kind of where some of this with Kevin McIntire fell into the picture. We're fast forwarding about, so Kevin has about a 30-year history in law enforcement. Well, on April 10th of 2017, Wrangler was charged with felony possession with intent to distribute marijuana. This was in Stevens County, Kansas, when he got that charge. And for that, he received 30 months suspended sentence with 24 months of supervised probation. So how was Kevin involved? Well, on September 23rd of 2023, Tad Cullum emails Kevin McIntire a video of Wrangler with a gun. And in that video, Wrangler fires 3 shots.
I've actually
Um,
heard about this.
yeah,
So
the
some of
video
my
Go
yeah,
ahead.
some of my I've had a couple of contacts that reached out to me to say that now in the with their understandings, because they weren't firsthand, their understandings was that Tiffany took the picture of the video and waited and held on to it and sent it in when it benefited her. Depending upon, and I don't know what the benefiting her meant, if it was regarding the custody or trying to get Wrangler to do her bidding, but so I'm familiar with this. I've heard this story a couple of times. So it coming to light, it's just interesting to see that it keeps developing and going forward.
Yeah. I was
Yeah,
reading comments.
Pine Needle, I don't put everything out there. All the stories that I get, I don't put them all out there. I wait until somebody else is like, "Hey, get this. I just got this information." I'm like, "No, I've had that for 3 weeks, but I'm so glad you can validate it." I'm very I think I drive Carrie crazy because she'll tell me something. I'm like, "I totally knew that." She's like, "Why didn't you freaking tell me?" I'm like, "'Cause I didn't know if it was true or not." I was waiting.
Hal's comment,
I
that just
love that.
cracks me up. I mean, funny, not funny, but true.
Right.
And yeah. So, let me get that up there. All right. So the video that Tad emailed. Okay. So the video was from August 23rd of 2022. On
20
January
okay.
24th of 24, Wrangler pled no contest to the charge of possession of a firearm after having a former felony conviction, which was that charge back in 2017 for the intent to distribute marijuana. All right. So at the time, Kevin was employed as the agent in charge of the District 1 Narcotics Task Force. And let's see. So let me go over here because we have that. So this is going to be Wrangler's gun charge. Let me get that pulled up here real quick.
Carrie, just For funsies, and I know you're going by Heather, but I'm used to calling you Carrie. I'm just going to point out that Carrie
Hey,
Moody and the
call me
Kevin.
whatever everybody else has in the last few weeks. It's okay.
I'm just gonna just
It'll
for
be all
funsies,
right.
as I'm sitting here looking at the slides, I'm just like, hey, there's something interesting. Is Carrie Moody and Kevin McIntire the same initials? I just want to point that out to you. So maybe going by Heather is a better option for you. I don't know.
Right. Yeah. Yeah. I noticed somebody else pointed that out earlier too. Kind of funny.
I mean, it's all in the theme, right?
I
It's
mean, of
just
course. We were probably related or something, I'm sure.
you better be careful with that rumor.
I know, huh?
Ancestry.com would come after you for an interview. Yes, Pine Needle protagonist Kevin is on the witness list. Yes, he is on the state's witness list, but so is any law enforcement official that's involved in the case. To my understanding, Kevin was on site when the car was discovered.
Right.
We've not brought that out there, but Kevin was there when the car was discovered. He was one of several law enforcement representatives that was on site that day. So him being involved, we don't know what that means. He's involved from a law enforcement standpoint, not a criminal standpoint, as far as we understand so far. That affidavit has a lot of words in it.
All right. So I can do this. So this is Wrangler's charge. This was dated, I gotta go back over that. I can't see the comments while I read this, but this was filed looks like November 16th of 23, possibly,
Yeah.
in Texas County. So Kevin McIntire this is some of his background. So this will give you a good idea of what Kevin McIntire's background is. He is a certified police officer currently employed. Now, this is at that time in 2023. Certified police officer currently employed as an investigator for the District 1 District Attorney, assigned as the agent in charge of the District 1 Narcotics Task Force. I began my career as a police officer in August of 94. So he's a few years older than me. So he had to have been like 21, 22-ish probably when he got into law enforcement. He received his Council on Law Enforcement Training and Education, which is CLEAT, Basic Peace Officer Certificate in 95. From August of 94 until March of 2001, he served in a number of positions at the Ardmore Police Department, including patrol officer, school resource officer, crime scene investigator, and detective. Beginning in March of 2001 until March of 2007, he served as an investigator for the District 20 District Attorney assigned to the District 20 Drug and Violent Crime Task Force. Beginning in July of 2010 until March of 2012, he served as the Chief of Police for the Keys Police Department until appointed as the Sheriff in Cimmaron County. In January of 23, he returned to the position of Chief of Police for the Keys Police Department until he was hired into his current position September of 2016. That in February of 2016, he received an advanced peace officer certificate application. Receipt of an advanced peace officer certificate is based on a formulary process that considers an officer's years of service, their training hours, their college credit hours. He says he has more than 70 college credit hours with steady focus on criminal justice, more than 2,100 hours of training in various law enforcement related topics that include approximately 430 hours related to narcotics investigations, 226 hours related to major crimes investigation, 98 hours related to conducting interviews and interrogations, 86 hours related to law enforcement leadership, 44 hours related to search and seizure, 32 hours related to crime scene investigation, and 60 hours related to developing and providing adult instruction in law enforcement topics. He says he's authored and presented several training courses for law enforcement across the state of Oklahoma on topics that include drugs in the brain, search warrants, knocks and talks, criminal interdiction, criminal interdiction. I've
Yeah.
never heard that word. Criminal interdiction management and communication and mental health. He's also authored and presented a number of training courses and informational briefings for school employees and administrators, student bodies, civic groups, and community members on topics that include recognizing child abuse, drug addiction and use, drug recognition, current drug trends, black market marijuana operations, human trafficking, bullying, first aid, CPR, and bloodborne pathogens. He is currently a member of the Association of Oklahoma Narcotic Enforcers and has been a member of the governing board for that association on 2 occasions. As a member of A1, he maintains ongoing personal relationships with officers and investigators from across Oklahoma and other states. Through these relationships, he's able to gather, share, and compare information about criminal behavior and crime trends across the United States. This information allows me to remain educated on current crime trends and potential causes of criminal behavior, as well as common practices employed by those committing crimes in the area. So, when it's come out that you see these friends on his Facebook and stuff, I've received messages from numerous people in law enforcement or have a spouse in law enforcement or what have you. And, they indeed are friends with him on Facebook, but it's not like they're, you know, buddies going out every night. It's not, but, just like many of us have friends on our Facebooks that we're not like besties with, right? So,
Correct.
anyway, so he did all that. He facilitated, or actually, I think he still does, facilitates monthly intelligence sharing meetings for law enforcement officers from agencies in the region within and surrounding District 1. The meetings are used as a regular opportunity for officers in the region to discuss current trends in crime and criminal behavior and collaborate in the investigation of current crimes. Through this group and the relationships it's formed, I'm able to gather, share, and compare information about criminal behavior and crime trends across the region. This allows me to remain educated on current crime trends and potential causes of criminal behavior, as well as common practices employed by those committing crimes in the area. He meets quarterly with investigators from other district attorney task force offices located across Oklahoma. In each meeting, those in attendance participate in a roundtable type of discussion detailing recent investigations and activity. Through relationships formed through that group, some of which have spanned more than 20 years, he's able to gather, share, and compare information about criminal behavior and crime trends across Oklahoma. This allows me to remain educated on current crime trends and potential causes of criminal behavior, as well as common practices employed by those committing crimes in the state. Are there any like comments or questions that need to be addressed?
Just
I
so
can't see anything.
no, but I am going to point out that Mama Moo, and if I could highlight it for you, I would. But Mama Moo's, and I thought the same thing, Mama Moo, when I read this. I was like, horn tooting much, and just one thing after another. And I get it. There's probably a need to qualify yourself for certain things, but good night. And this is the first time I've seen one of these, so this may be normal. I don't know, but that was the only thing. Is it sounds like a horn tooting document. Like, look at me, I'm so great and I'm so awesome. I did all these things. It's so wonderful. Lynn, we're going to catch up to that in a second. We are not done with this.
Yep, we are
Lots
getting
of
there.
great information.
Yep, Lynn, wait for it. All right. So then we're going to go on after he's tooted his horn a lot. He has knowledge and is aware of all the information contained in this affidavit through direct participation in this investigation or from information provided to him by other law enforcement officers assisting in the investigation. Since the affidavit is being submitted for the limited purpose of establishing probable cause for the arrest of the defendant named above, he has not included every fact known to him concerning the investigation, which is very normal for probable cause statements. It's just like skims the top of it. That's about it. Says he has set forth only the facts that he believes are necessary to establish probable cause to support the arrest. So here's the probable cause statement. On or about the 23rd day of September of 23, I received an email from Tad Colum. The email included an attachment that I recognized as a video file and the date of 23rd day of August of 22. So 13 months earlier was the date of the video. Tad advised me that he had received the video from Wrangler Rickman on that day in August and had maintained custody of the video since that time. I viewed the video contained in the attachment and immediately recognized the person in the video as Wrangler Rickman. I recognized the location where the video is recorded and knew it to be a residence owned by Colum and at one time the primary residence of Rickman. The residence is identified on Google Maps as blah, blah, blah in Cimmaron County, Oklahoma. So in the video, Wrangler can be seen handling an AR-15 style rifle. He refers to his location as quote unquote Rickman Arms. He identifies the rifle as a 50 Beowulf caliber build. He shows the loaded rifle magazine. He loads the rifle and he fires 3 shots from that rifle. Kevin McIntire goes on to say that he researched Wrangler's criminal history. And in doing so, he found that on April 10th of 2017, again, this is on September 23, that on April 10th of 2017, Wrangler was convicted of a felony in Stevens County, Kansas. He received a 30-month suspended sentence with 24 months supervised probation. The charge in that case was possession of a controlled dangerous substance with intent to distribute, and it was marijuana. That on or about the 26th day of September 23, Kevin spoke with Wrangler while he was assisting the Cimmaron County Sheriff with another call for service. And at that time, he asked Wrangler if he remembered the video, and Wrangler said he did. He asked Wrangler if he remembered when the video was taken, and Wrangler initially said he wasn't sure. So Kevin asked Rickman if the video had been taken sometime during the summer of 22, and Wrangler said yes. He then asked Wrangler if the video was taken after he had completed his probation terms in Stevens County. Wrangler again says yes. So the relevant Oklahoma statutes that states in part, it shall be unlawful for any person convicted of any felony in any court of this state or of another state of the United States to have in his or her possession or under his or immediate control or in any vehicle which the person is operating or in which the person is riding as a passenger or at their residence where the convicted person resides, any pistol, imitation or homemade pistol, altered air or toy pistol, machine gun, sawed-off shotgun or rifle, or any other dangerous or deadly firearm. So, Oklahoma is an open carry state, but if you have a felony in another state, you can't come to Oklahoma and carry because you're going to be arrested. So the conclusion is that your affiant prays based on the foregoing facts that the court will find probable cause to believe that the defendant named above committed the crimes listed below, possessing of a firearm after a former felony conviction. And that was dated on November 3rd of 23.
Oh boy.
Yeah. So what are
Good
the
night.
thoughts on that? So my first thoughts were, okay, so Tad and Tifany hung on to this video of Wrangler for 13 months as
Leverage.
dangling it over his head as leverage. Exactly. That's how I felt about it. I wonder, what does the chat think?
Well, while the chat responds to that, given what we know about the timeline of the child custody back and forth, I absolutely think this is related. And Wrangler's made statements that are in court documents that says he's got to do what she tells him to do. So it's Granny already setting up to get the kids. That's well stated, Mama. Very well stated. Premeditated. Yeah, it's hard not to believe it's not. It really is hard to believe this is not premeditated. Oh my goodness. Does anybody disagree? There's a lot of folks agreeing. I don't, if you guys are in the chat and you don't agree with what you see or what you from others, the disagreement's not a big deal. It opens up the conversation.
Yeah,
So
not at
feel
all.
free to, and then Carrie, check your messages. There's another mod that needs a wrench.
Okay.
So it's not only that Tad was working on the cop too. I see the deal here. So it's I don't know, and it's such a small community to know that situation where they held on to a piece of evidence that should have been turned in right away, but they held on to it. And then McIntire makes he's got the affidavit for that. It doesn't look good. It doesn't look good. It's easy to believe that there's some shenanigans taking place in there. Misplaced Texan. I feel you. I'm from Texas myself. Very much suspect that the video was held for so long, and the fact that Tad was the one to send it directly to KM.
And
Yep.
email it at that.
Yep. Kathy Lees is playing both sides. You know what? What if that's the case? And I don't know that somebody's actually said that out loud, Kathy. So if I'm understanding you correctly, maybe that's what's happening. Is Tad and Tifany have been playing everybody that they could play to get their way. That maybe Kevin is as much of a shenanigan player as what they think. Maybe he got played too, or I mean, you get put between a rock and a hard spot because you're law enforcement. You get this video and you're like, damn it. Now what? This is a good kid. His mom's crazy, but I'm screwed. I have to do my job. Or I don't know. There's a lot of different scenarios to walk through. And if you've heard me in lives before, I have not determined what bucket to put Kevin in yet. I don't know if I'm a fan or not of him yet.
I'm in the same.
It's hard
I'm
to.
sure people see my comments in the group. I'm in that same category.
Well, comments in the group, they're easy
sure.
to misunderstand, and depending on where you feel you're at, if you've already made an opinion, those comments can look one way or another. But honestly, God, it'd be great to find something definitive that's not court documents, because that's what we have is all the court docs from his career, the different arrests he's made, how he's impacted the anti-drug law enforcement community.
And he's done a lot. Like I sat for probably 6 hours one day. I don't know how long it took. And I wrote down every single conviction that shows up on OSCN that Kevin McIntire was an arresting officer for, going back to the very beginning of his career. What I can say in that aspect, he has taken a whole lot of really bad drugs and really bad people off the streets of Oklahoma. So for that, I'm behind him on that part.
Sure.
The rest of this, I'm just like, I haven't made up my mind. So
WTF.
If anybody thinks I haven't. I just think that he's done a really good job as far as that part is all concerned. With this, I don't know yet. So I'm going to let you read the next one. So the next, after those gun charges, so what filed next, what came next with the Wrangler situation was he got this domestic assault and battery charge. And let's see, let me pull that up. February 21st, they did this motion to revoke his suspended sentence from the gun charge. And then on March 21st of this year, he did a recognizance bond in order to enter rehab. It's important to note, to me anyway, that the Boise City Police Department were the arresting officers on the domestic assault and battery charge. Kevin McIntire had nothing to do with this.
Yeah.
So when he ultimately got into the big trouble where he was going to be put in jail or he was, ordered to go to rehab, that was done by 2 officers in Boise City that arrested it on that. So let me pull that up real quick.
And while you're doing that, to the chat, I think maybe one of you sent me a message on Facebook. I got it. I sent you a message back. If you will respond to me, I'd like a little bit more information on that. I don't want to say anything about it, though I would love to say something vague if you are up for it. So if you will check your messages for me, that would be outstanding. Because if that's what I think it is, I'm about to cry. That's just unbelievable. So just to throw a little teaser out there for the rest of you. Okay. So what we have in front of us is the motion to revoke suspended sentence. So I, George H. Leach III, the undersigned district attorney of said county, in the name and by the authority of the state of Oklahoma, show that the above named defendant, Wrangler Cole Rickman, we're going to have to scroll up, the messages are in my way, on the 25th day of January 2024, entered a plea of I hate Latin, nolo contendere, right? Y'all tell me if I'm wrong on that, to the crime of possession of firearm after former felony conviction, a felony 210 or at OS, that's probably the statute right there. Further that on the 25th day of January 2024, the court sentenced the above named defendant to sentenced to a term of 6 years with all suspended under the custody and control of the Oklahoma Department of Corrections pursuant to the district attorney rules and conditions of probation entered by the court under statutory and or court-imposed rules of probation. Further, that the said defendant is in violation of the terms and conditions of probation of said judgment and sentence, having failed to follow Rule 4 and 6 of his probation, those are attached. On February 21st, defendant was arrested and charged with domestic assault and battery in presence of minors and public intoxication. February 21st, defendant was arrested and charged with domestic assault and battery on his mother-in-law. The aforesaid acts violated the conditions and is good cause for the court to revoke said suspended sentence. Wherefore, the state of Oklahoma requests that the court set a date for hearing this petition, and that the suspension clause in said judgment and sentence be set aside and revoked, and that the sentence be carried out in full. So, in the chat, does anybody know what that's? We know what it's following, just to give you guys an opportunity to chime in. Give your thoughts on that document. Do you want me to go forward with reading the next one on the screen, Carrie?
Yeah, if you don't mind, give me just a second and I'll be right back as well.
You're good. You're good. But
Okay,
I need somebody to scroll though.
Okay. Let me scroll it down for you just a minute.
Okay. And so the personal, I hate this word, recognizance appearance bond. So release with conditions for treatment. I hereby request the court to order my release on this personal recognizance. I've been advised that anyone so released who willfully fails to surrender himself within 5 days following the date of appearance set forth herein shall, upon conviction, be guilty of a misdemeanor and may be fined up to $1,000 or imprisonment for not more than 1 year or both. Further, that such criminal prosecution shall in no way interfere with or prevent the exercise by the court of its power of contempt. I have been further advised that anyone so released who willfully fails to surrender herself within 30 days following the date of appearance set forth herein, or who willfully fails to comply with these terms, shall, upon conviction, be guilty of a felony and may be fined up to $5,000 or imprisonment for not more than 2 years or both. In consideration of such release, I hereby agree to appear in person in said court within 72 hours of release or departure for any reason from inpatient treatment at Salvation Army, Oklahoma City. You have a blank phone blank. Hereafter referred to as Treatment Center. Treatment shall start on the 22nd of March. 2024 at 8 o'clock in the morning. Upon leaving the facility, I shall appear at such time as directed by the court and there to abide the order of the court until finally discharged. In further consideration of such release, I hereby agree and understand that special conditions apply to the issuance of this personal recognizance bond as follows. The defendant shall not have in his possession or use alcoholic beverages or intoxicants or drugs of any kind except those prescribed exclusively for the defendant by a licensed physician. The defendant shall report to the treatment center or the treatment facility for successful completion of not less than a 6 months inpatient alcohol substance abuse treatment program. The defendant shall require a representative of the treatment facility to immediately notify this court of the defendant's release and or departure from said treatment facility under any circumstances, and shall direct the facility to provide reports to this court each 30 days concerning defendant's treatment and recovery process, thereby waiving my privacy rights. The defendant shall report to this court within 72 hours of release or departure for any reason from the treatment facility, but not later than 5 p.m. on the 25th day of September 2024. The defendant shall not violate any city, state, or federal laws. Failure to comply with these conditions shall result in the immediate revocation of this bond. I further understand it to be my duty to keep the court advised of any change of address, and that my failure to do so will constitute no excuse for my absence and the resulting consequences. So this was subscribed and sworn on the 24th of March, 2024. So between the two documents, what do you guys in the chat think was that all about? Any ideas? I'm going to come out of my extended screen so I can see the chat a little better. So in short, what we have here is, let me switch over to the live chat because my chat room changes. So Wrangler was arrested, and he was arrested for some charges that are not fun to talk about. And he was ordered to enter into rehab. So there was a motion to revoke his suspended sentence that was on February 21. A month later, recognized a bond, ordered to enter rehab. So that's how he ended up in rehab. Thank you, Truth. That was a mouthful. So, yep, Kathy, that's right. Agreement to abide by set forth court requirements. Yeah, he's got to do what the court says. He's got to stay in the treatment facility. If he doesn't, he's got to report to the court. Thank you. So he's in rehab because he did choose it. The choices were pretty slim, right? But he did choose it. That's where he's at, and that's how he got there.
Yep.
So it's now there's been a lot of talk about the DV charges. We do understand what those were. We are not permitted to go into them. It's not our space anyway. If folks want to out those, they can, but it's not what you think.
Right.
I have been a part of a DV case in the past, and I know those in the chat personally. I know they've also been a part of DV cases, and this is not your everyday average DV case. This is one of those things where
it's a sad
emotions were.
situation.
It really is. But it's not somebody had to go to the hospital or seek medical treatment. We'll put it that way. So once we have once we can go further into that, we would very much be happy to do so, because again, and I know we've gotten a lot of flack and a lot of interesting comments about the live that we did on Wrangler's. It wasn't really on Wrangler's behalf. It was trying to clarify Wrangler's situation as best we could.
Yeah, and
because
backing
he
it up
deserves
with,
a
like,
voice.
the facts and
Yes.
that's
He
what
deserves a
that was.
voice too, because nobody's speaking for him openly. And so you can't justify his decisions. You can explain them. That doesn't mean the explanations are very good. And so there's a lot going on there, but that's why he's in rehab. From a psychological standpoint, why did Wrangler get in TA's crosshairs versus her other children? Was he just weaker? Are all TA's kids by the same man? That's a great question. I know not Cole, that's Wrangler's middle name. Wrangler's got a brother. He and his brother.
I believe her children are all from the
I
same
want to
father.
say that the only one I was worried about was the last one. Now there are some court documents that there's some name changing stuff in there.
Yes.
So I don't know all the dynamics. I don't know the relationships. Thank you, Betsy. I'll have the same dad. I don't know if Wrangler's the one-off or if any of them have anything to do with their mom. No
Right.
clue. We've never really found a reason, a temptation, a motivation to go down that rabbit hole either. It just never really came up. But it's and maybe it means something. Maybe it goes to Tifany's character. Maybe it helps to explain Wrangler's position. It's hard to say.
Right. So from there, this old fart is wore out.
We appreciate you,
Casey's
Casey.
Corner, you sound like me. Thank you so much for being here. And yeah, you can always go back and watch the replay. We
Absolutely.
leave the chat up, so you'll be able to, if you watch the replay, you can follow the chat along with it as well. I hate it when I go to watch a replay because I don't catch much of anything. I want to watch as it's happening live, and I want to go back and watch it, and I want to see what the chat's saying too. But if they've
I'm
edited
watching
or
them.
yeah, or they didn't put that setting on, then you can't see the chat. Um, so where we're at now is this, and this is investigator indicted in embezzlement case. Many of you have already heard about all of this, so we're just going to give you those facts as we have them, and then you can take that information and you can form your own judgments, your own thoughts, what have you. But in April of 2004, there was a grand jury investigation and an indictment. I put, why could this be important? Well, the defense has asked for information regarding whether any testifying government agent is under investigation for taking money from informants, lying on warrant applications, and or stealing money, weapons, or property from informants or suspects. December of 2007, Kevin McIntire did indeed take a plea deal in which he could not seek any law enforcement positions for 3 years. Yet he was appointed the chief of police in Keys in July of 2010. So not 3 years. So he was appointed. Was that a loophole? He didn't seek it out. He didn't apply for a job. He was appointed. Maybe that's a loophole or something like that. I'm not sure. But so this is, let's see, we have the grand jury request. So give me just a moment. Pull that up here on the screen. All right. So this was a long document, but it's a grand jury. So it went over a lot of different
Mhm.
cases and stuff. We get down here to DA District 20. This grand jury focused a significant amount of time investigating allegations of wrongdoing arising from DA District 20. This investigation stood out because it concerned possible wrongdoing within a law enforcement agency. From this investigation, the grand jury returned one indictment charging one individual, Kevin McIntire, with one felony count alleging embezzlement. The grand jury's investigation focused on events occurring between April 26th of 2004 and February 28th of 2007, during which time the defendant was employed as an investigator for District 20 DA. As a district attorney investigator, the defendant was entrusted with property consisting of, but not limited to, money seized from arrest and execution of search warrants, with said property being entrusted to the defendant to be held as evidence and or for use only for a public purpose, and more specifically for use in connection with the defendant's public duties at the said District 20 District Attorney Drug Task Force. In particular, the grand jury's investigation focused on the defendant's April 2004 arrest of a subject from whom the defendant seized an amount of U.S. money in the sum of approximately $2,600. The defendant seized the referenced funds and subsequently wrote a report in which he made no reference to the amount of currency seized from the arrestee. Furthermore, the defendant failed to file or cause to be filed a petition or notice of intent to forfeit said funds. So keep in mind, this is back, 2004 to 2007. It's been quite a while, but still. The grand jury learned that on November 7th, 2006, the 2004 arrestee filed an action seeking the return of funds seized by the defendant, at which time the prosecutor, preparing to answer, made an inquiry of the defendant regarding the status and location of those seized funds. Well, the defendant was unable to produce the seized funds, and he offered no explanation as to why he did not file or cause to be filed a petition for forfeiture or a notice of seizure and intent to forfeit the referenced amount seized. Initially, the defendant was not advised that circumstances surrounding the missing funds would be further investigated, and the defendant agreed to pay the money back by making installment payments. However, on or about February 21st of 2007, between 4 o'clock and 5 in the afternoon, the defendant was advised by the DA for District 20 that the DA decided to call for an independent investigation regarding the referenced funds. Later that same evening, the defendant reported his discovery, all of a sudden, of an alleged burglary of the DTF office located in Ardmore, Oklahoma. A preliminary inventory of the DTF immediately following the alleged burglary revealed no missing guns, no missing drugs, digital cameras, at least one laptop computer, and U.S. currency located throughout the offices within the DTF office, easily accessible and or in plain view. It was finally determined that the defendant was not only the person who discovered the alleged burglary, but also the last person to leave the office on February 21st of 2007, and that he did not set the alarm when leaving the building. It was also determined that the only items supposedly taken during the alleged burglary were funds in the possession of or entrusted to the defendant and estimated in the amount of approximately $3,000. On the morning of February 22nd, 2007, at around 10:30 a.m., while in the course of rearranging the recently quote unquote burglarized office, the defendant allegedly discovered the funds seized during the 2004 arrest.
Marvelous.
Yeah. A lot of coincidences.
Lucky break.
I mean, that's really lucky to have found them during the course of rearranging a burglarized office where they found nothing burglarized. But Ardmore Police Department conducted an investigation of the alleged burglary and said investigation led trained investigators to conclude that the event occurring on February 21st of 2007 was actually a staged crime scene, absent evidence of an actual burglary. It became obvious from the grand jury's investigation that a short time after learning there would be an official investigation of those missing funds seized by the defendant, he may have staged the burglary of the DTF office and may have created an opportunity not only to acquire or convert funds, which he used to replace those 2004 seized funds, but also to stage an opportunity for his discovery of the envelope in which the defendant enclosed the replacement funds. He got a lot of lucky breaks on this.
Sure
Investigation of this matter required the appearance of a number of witnesses, mostly law enforcement officers. One of the material witnesses appearing before the grand jury was the elected DA. Early on, this grand jury realized that a majority of the material witnesses were members, obviously, of the DTF or law enforcement agencies who routinely worked with the DTF, the Drug and Task Force. This group of witnesses is part of a brotherhood relying on each other for the success of their jobs as well as their safety. This level of law enforcement requires a strong bond of trust. Witnesses were placed in the difficult position of being called to testify in a matter that could and did result in the prosecution of one of their own. The grand jury recognized that it was an arduous task placed on the witnesses. Overall, the grand jury applauds the witnesses who testified in this matter, starting with the elected district attorney, who exercised his leadership wisely by requesting an independent investigation. Most witnesses appeared, of course, without anticipating the outcome of the grand jury's investigation. Most witnesses carried out their oath to tell the truth, regardless of what implication the grand jury's investigation may have on them individually or their agencies. The District 20 DTF practices in place at the time of the events relevant to the grand jury's investigation included the practice of agents being required to complete paperwork, which would prompt the filing of a forfeiture action for seized funds. In other words, prosecutors would have no way of knowing exactly what should be forfeited from seized property, but the submission of a form for the prosecuting agency by the DTF agent. This practice is not unique to the District 20 DTF. In this case, the embezzled funds were not documented by the DTF agent. The collective opinion of the law enforcement officers assigned to investigate the alleged burglary was that the DTF office lacked significant signs of being a real crime scene. Questions regarding the condition of the alleged crime scene, including property that was in plain view but not taken by the intruder, coupled with the defendant's conduct, called into question whether the alleged burglary was actually the subject of reprisal and cover up for the embezzled funds. During this investigation, the grand jury learned about the procedures and/or common practices used by DTF throughout the state. The grand jury gained an appreciation for the purpose of DTFs and has come to realize the necessity of keeping DTFs in operation so as to address the war on drugs from a community-based perspective. Agents working on DTFs constantly handle cash in the form of drug forfeiture funds and buy money. The nature of DTF enforcement lends itself to the need for many checks and balances. This grand jury realizes there are already requirements for agents to generate reports and complete certain documentation regarding the receipt or withdrawal of cash. However, documentation is not always timely completed. Further, this grand jury is aware of various other requirements, such as the requirement that a second party count funds for verification purposes. These types of procedures seem to be lost in routine and allow for abuse. Given the type of work carried out by DTFs, one cannot afford to deviate from routine procedures established to protect the integrity of this specialized area of law enforcement. It's obvious to the grand jury that protocol and procedures regarding various aspects of work performed by DTF agents are already established and in place. However, for various reasons, agents sometimes fall into a routine of not following well-established protocol and procedures. It's obvious that law enforcement officers working in this area would benefit if they were provided assistance by support staff in carrying out basic clerical tasks. The grand jury believes the necessary checks and balances to guard against wrongdoing are already established and should be strictly enforced by any and all agency officials responsible for administrating a DTF. In summary, DTFs are a necessary faction within law enforcement, and administrators must tighten up the ranks across the board. So that was his grand jury indictment.
So it sounds like they can't prove how the money moved, but they can prove that it was vulnerable at some of the processes that were parts of the steps to the process that were overlooked. And that would have been Kevin's responsibility. And so that's how I'm taking it, Carrie. Is that is that how you read it? Is that how you interpret it? That he we don't know how that money got moved around, but we do know Kevin could have done more to take care of it. Yeah, you're gonna want to go through those comments. There's a couple of funny ones in there.
I
Nope.
see.
So Connie's comment, you need to go back to Lori's comment about Tad doesn't need a legal book. Some of those folks need a Bible. Yeah, so it's and I guess there was a comment made in the group about this whole situation not too long ago that it made our group stop and think as we were researching this, is that just for funsies, right? Not a justification, an explanation. When you are the person that's responsible for that kind of thing, if it goes missing, you're responsible. If you don't follow the processes, if you don't mind the way things are supposed to be done, if you don't do what you're supposed to do. I love our chat.
I know.
I just love our chat. Oh my gosh, they're so awesome. So it may be that he didn't move anything, but he didn't protect it very well either, is what it sounds like. And I would really love to have his side of
Oh
the
my
story on
gosh,
that
me
one.
too. Me too.
It's I don't know, and it's one of those things too that he was told you can't be in law enforcement for 3 years, and then he goes into the drug task enforcement aspect of law enforcement. You have to wonder. There's more to the story when it's sometimes things are more complicated and more convoluted than they look. Not everything's cut and dry. So
Yeah. So I'll let you read this next one, and this is his
outstanding.
where he is actually indicted, the news article. But let's see. Okay, so let me go back one because this is another issue he had there. All right, so
Okay.
this is the news article where he was former district attorney enters a plea bargain.
Okay, so we have here is the investigator indicted in embezzlement case. So that's actually there's articles out there you can look, and my screen went blank, but that's okay. Oh, it went blank all the way around. Oh, there's the article. She was bringing up the article for me. So, and I think you've read this article before. Do you want me to go ahead and read it again?
Yeah, if you don't
Okay.
mind, since it just
Yeah.
kind of flows with what we were going over tonight, might as well
Yeah.
just
Yep.
wrap it up with what happened.
Yep. So the former district attorney task force agent enters plea bargain. Former Carter County drug task force strikes a plea deal. Kevin McIntire, the man accused of embezzling money following a drug bust in Carter County, won't face jail time, and K10's Meredith Saldana reports that. Kevin McIntire initially appeared in court today for a preliminary hearing on felony charges of embezzlement. However, he waived his right to trial and accepted a plea on a lesser charge. Keeping in mind, this was back in December 13th, it looks like 2007. McIntire was initially charged with embezzlement, a felony, in October after being indicted by a grand jury. Today, though, he pleaded guilty to a misdemeanor charge of the willful neglect of duty by a public official. According to his attorney, David Slane, words today. Police officials are supposed to fill out paperwork after seizing funds from suspects under arrest. In his plea, McIntire admitted to neglecting to account for the money by not filing a report to the DA's office. Slane says he entered a plea to a misdemeanor charge, and we feel that it's more appropriate under the circumstances in light of who he's been. And so we entered a plea of guilty today, and we got the matter resolved, and he wants to move on with his life. His plea bargain includes a 1-year deferred sentence, a 3-year deferred prosecution agreement, and the surrender of McIntire's police certification, which includes an agreement not to seek any type of law enforcement employment for 3 years. He's also required to pay the unaccounted money back, $2,300 to be exact. So that's what they're saying. It's based on just as Carrie read from the affidavit, the court document. Oops, I didn't do my job properly. I lost some money, but don't worry, I'll pay it back. But here's the rest of it. I don't know how it got here.
Yeah, can I make payments?
Right.
Can you put on my credit report?
Yeah, don't report me to credit agencies. Can you imagine? Good night.
Jeez.
So
And then I think there's one final one on that one, and that is just
TikTok, Kevin. Pine Needle, you crack me up. Oh my gosh. Again, we don't know which bucket to put him in. His past, I say this loosely, your past doesn't define you, right? You make different
Yeah.
choices, hopefully based on what you've learned. I'm hoping things are different, but I'm open to learning more about Kevin through Kevin specifically. So thank you,
Definitely, and I'm
Mama.
the same. I feel like, people do and can change every single day.
Yeah,
So, was
absolutely.
it I mean, I'd be tempted to say, okay, maybe it was just an overlook, wasn't paying attention, blah, blah,
Yeah,
blah.
it's possible.
However, you have like a staged burglary and things like that on
You
top of
thought
it.
this through after the fact, like, oh,
So,
they know.
yeah.
Let's make it look good. At least he tried. He thought the details through. So on the screen now, we have investigator indicted in embezzlement case, October 8th, 2007. Former investigator Kevin Bryant McIntire, 35 of Ardmore, is charged with one felony count of embezzlement in a state multi-county grand jury indictment unsealed today in Carter County District Court. He was released on his own recognizance pending further court action. David Slane, McIntire's attorney, could not immediately be reached for comment. McIntire is a former investigator for a drug task force that operates in Carter, Love, Johnston, and Murray counties. The grand jury alleges McIntire seized around $2,600 during an April 2004 arrest, but failed to accurately report the amount of money seized and never filed a court petition to have the money forfeited. When it came to light that the money was never correctly processed, McIntire allegedly staged and reported a burglary at the task force office, said Oklahoma Attorney General Drew Edmondson, whose office administers the grand jury. In the course of cleaning up after the burglary, McIntire claimed he discovered the missing funds. That's awesome. And that's what Edmondson says. Now, Edmondson said, though, the never mind. If you're listening to the live, you'll figure it out.
She's all never mind.
Just do your due diligence. I don't know. An inquiry into the missing funds began in November after the person from whom the money was seized filed a court action seeking its return. I'm curious about that now. When McIntire was asked about the money, he was unable to account for its disappearance or his failure to seek its forfeiture, the indictment alleges. He initially offered to pay the money back by making installment payments, the grand jury reported. However, on February 21st, McIntire was informed that an independent investigation would be conducted. Later that same evening, McIntire reported his discovery of an alleged burglary of the Drug Task Force office, the grand jury said. Suspicions were raised after a preliminary inventory of the Drug Task Force revealed no missing guns, no missing drugs, undisturbed digital cameras, at least one laptop computer, and U.S. currency, all located throughout the offices within the Drug Task Force, easily accessible or in plain view, the grand jury reported. Furthermore, the only items supposedly taken during the alleged burglary were funds in the possession or entrusted to McIntire, the grand jury said. Oh my goodness. The following morning, McIntire claimed he found the missing funds while rearranging the Drug Task Force office, the indictment states. Ardmore police officers investigated the alleged burglary and concluded it was actually a staged crime scene absent any evidence of an actual burglary. An investigation into the Drug Task Force is continuing, Edmondson said. Is this another Kevin Gone Wild moment? Let me just say again, I love our chat. You guys are awesome. So the money goes missing. He doesn't follow protocol. He stages a burglary. He's rearranging the office post-burglary where it's later discovered there was no burglary. And lo and behold, it looks like the money essentially was misplaced in the office after during a burglary. Oh, but he pled guilty. So here's the thing. He pled guilty.
Mm-hmm.
He's like, okay, all this happened, but I want to plead down to a misdemeanor because I'll confess. And so,
yeah, and like Hal said, it was a first-time offense.
yeah,
He has nothing else that I could find on his record. I mean, there's nothing else like to this extent whatsoever. It was 20 years ago. Do we give the benefit of the doubt? I don't know. That's not for me to decide at all. But these are just the facts for you guys, and then you can take it from there,
right?
and come to your own conclusions. Because I don't know, is he a good guy? Is he a bad guy? I've heard both sides of that.
I have
I
too.
mean,
I've heard he's great. He's awesome, wonderful individual, caring, loving, supportive, Christian-like, and I've heard he is the biggest asset to walk around the area. And so maybe it's just, and I don't know who. I mean, I don't know the people personally that report to me, so I don't know if it's a birds of a feather
he
issue
loses
or if it's
funds. Yeah, he's not going to be holding my cash. And so how many of these offenses total? So we only found one.
Yeah.
This one right here that I have on the screen, this was August 2012. Cimmaron County Sheriff's Department was investigated.
Yeah.
We don't know that this actually had anything to do with Kevin. However, they were investigated by CLEAT, which is the Council of Law Enforcement Education and Training. And at the time, Kevin was the interim sheriff for there.
Yeah.
Cimmaron County. And Kevin said that investigators at the time, and again, this is 2012, so 12 years ago now, investigators were looking into actions by previous employees regarding it says personal, it's personnel documents. He says the department is cooperating, but since it concerns personnel, no names can be revealed.
Yeah.
And then the state of Oklahoma has used a council since 63 to train peace officers throughout the state. That's about it on that. I mean,
Well, that's a situation he inherited. He walked into that as the
inherited
interim.
that,
This is
yes,
not
so
something that was under this
exactly.
didn't occur under him. The sheriff that it occurred under left, was dismissed,
Yes.
whatever, was absent, gone, and Kevin stepped in. He would later become the sheriff, if I understand correctly. This interim position would turn into the real gig, I think. Somebody correct me on that one, but I want to say he later became sheriff.
He did become sheriff. I'd love to be able to, and maybe tomorrow I can do that, and I can do a really good timeline that we can post in the group or something. I was hoping to get that today, but I got a little bit sidetracked. But maybe tomorrow I can work on a timeline for all of these different events.
Yes.
Because if you guys are like me, I'm not going to remember the dates. I'm not going to remember. I'm
No.
probably not going to remember much of anything. But if I can see it like in front of me, then that helps me a
Yeah.
lot. So I definitely am like a visual type person. And then I think that was it. So the gag order, just once again about the gag order, it is preventing law enforcement, court personnel, and their counsel from discussing the case with news media reporters, etc. It does not affect anybody like myself, Tara, the group, anybody else. It doesn't even affect the media. The media can talk about it too.
Yeah.
But they're just not going to be able to discuss certain things. And then the medical examiner report. I wanted to just touch on that real quick because it came out this afternoon. I started getting messages. The medical examiner's summary report is not included in the order to be sealed. So that summary report it seems to me that it can be obtained when it's available. If it's available now, I'm not sure. But the summary report will be available. But the actual detailed medical examiner's report, the autopsy report, that is what is going to be sealed for at least 6 months.
Yeah.
So hopefully that makes sense.
And there's been a lot of questions as to why they would seal that. Why would you have that sealed? Why would you not release it? And the only thing I come up with is there's something in there that will likely upset and make it hard to gain a fair trial locally. There's got to be information in there that would just be enraging to folks. There's a lot of crime junkies out there, a lot of individuals who follow true crime all over the country, all over the world. And sometimes just certain elements of a crime just really get your blood flowing. So that would be my suspicion.
Most definitely. All right. Well, that was a lot of information. We try to keep these at right about 2 hours. So it's been 2.5. Maybe hopefully we can do another one where we had kind of thought maybe we'd open up the panel this evening, but we've already gone on too long. And we don't want to bore you to death because we do want you to come back next time. And I can see everybody else is getting tired. I know what we are. I know what age group we're all in over here. Like, okay, it's like 9:30, it's bedtime. But really, truly thank you, all of you, for joining us and taking the time to listen to us present this to you. Hopefully we were able to clarify a lot of things, clear up some things, and present some new information for you. And if you have any questions, you can always reach out to any of the mods in the Facebook group, and we'll kind of keep track of those questions. And then we can do a live where we can go through all of those. And maybe we can do like an open panel where, any of those of you that would like to come up and discuss it. A lot of you have a lot of great information as well. I mean,
Mm-hmm.
I can see many of you in the chat. Hal is one of them. Like, I love the information and his way of thinking. So if you have, those kind of questions, or you want to discuss things like that, just reach out and let us know. We're always available. And we will do another live here soon. We never know when, because we don't really plan. We don't really have like set nights. We don't
The
go live
information tells
early.
us when to go live. That's what
Real,
happens.
yeah, the information. We were going to go live last night, but then I was like, well, that's kind of silly, Heather, because the hearings are in the morning. What are you thinking? So then I quickly changed it, to do it tonight, so that we could at least cover the hearings this morning, which was about what I figured it would be. Not much of anything. So, but a couple things did come from it. And that's all I have. Again, everybody, I think, was wonderful in the chat. We appreciate you guys so much.
Mhm.
Please do give the video a like. It might combat some of those thumbs down that people had planned on doing before we started. So if you haven't yet, please go do that. That'd be helpful.
Yes.
And then reach out to us if you have questions or concerns or anything. Just reach out to us. We're always available, and we answer every single message. So that's all
That
I
we do.
have.
And that's all we need.
All right.
Thank
Thank
you,
you,
guys.
mods. The mods, you guys did great. I appreciate you very much.
Yes, thank you.
I always appreciate Tara. She knows I do.
Mhm.
She's like she's a little dream team for me. So I appreciate you so much, Tara.
Well, good,
Um,
because you're stuck with it.
But all of you guys in the chat, thank you for being here. I hope you guys have a wonderful, wonderful evening. Get a good night's rest.
Yes.
And we will see you in the group.
All right. Have
So,
a good night.
all right. Till next time. Bye-bye, guys.
Bye.